So what are deemed unfair immigration-related practices under the California Labor Code? Well, our labor code prohibits certain unfair immigration-related practices under Chapter 3.1 of Part 3 of Division 2. Chapter 3.1 was added in 2013 by Chapter 732. Labor Code Section 1019 makes it unlawful for an employer or any other person or entity to engage in or to direct another person or entity to engage in unfair immigration related practices against any person for the purpose of or with the intent of retaliating against that person for exercising any right that's protected under the Labor Code or by any local ordinance. The phrase unfair immigration related practice is defined extensively in this area of the Labor Code, and engaging in an unfair immigration related practice against a person within 90 days of that person's exercise of his or her rights protected under the Labor Code or a local ordinance will raise a rebuttable presumption of having done so in retaliation for the exercise of those rights. An employee or other person who's the subject of an unfair immigration related practice prohibited by this section, or a representative of that employee or person may bring a civil action for equitable relief and any applicable damages or penalties. A court may also impose different sanctions against an employer for repeat violations of this area of law, including a suspension of their license. This section also determines or defines the terms license and a violation. Section 1019.1 of the Labor Code makes it unlawful for an employer in the course of satisfying their federal law requirements to request more or different documents than are required by federal law, to refuse to honor documents tendered that on their face reasonably appear to be genuine, to refuse to honor documents or work authorization based upon the specific status or term of status that accompanies the authorization to work, and they are prohibited or it's unlawful to attempt to reinvestigate or re-verify an incumbent employee's authorization to work using an unfair immigration related practice. The law also says that any person who violates this section is subject to a penalty imposed by the Labor Commissioner or the Division of Labor Standards Enforcement, as well as liability for equitable relief. An individual may file a complaint with the DLSC, and the penalty recoverable for a violation of this section may not exceed $10,000 per violation. Section 1019.2 specifies that a public or private employer or a person acting on their behalf is prohibited from re-verifying the employment eligibility of a current employee at a time or in a manner that's not required by applicable federal law. An employer who violates this section of the Labor Code is subject to up to $10,000 civil penalty payable to the Labor Commissioner. However, note that this section does not prohibit an employer from re-verifying an employee's employment authorization in a time and manner consistent with federal law. They're also not prohibited from taking any lawful action to review the employment authorization of an employee upon knowing that the employee is or has become unauthorized to be employed in the U.S., or reminding an employee at least 90 days before the date re-verification is required that the employee will be required to present a document identified in the employment eligibility verification form. And they're prohibited from taking any lawful action to correct errors or omissions in a missing or incomplete I-9. And finally, Labor Code Section 1019.4 defines the term re-verify as well as re-verifying.